Welcome back, everybody, to Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, your host and amicable divorce expert. Why? Because that's all I do, amicable divorces. Today, we have a guest. Our guest is attorney Mitchell Port. He is a wills, trust, probate attorney. I know Mitch because I did his divorce. I mediated and filed. And he will come back for an exit interview at a later date. But what he has to say is so extremely important to all of you who do have significant assets in the transition out of the divorce into protecting those significant assets. So Mitchell is in practice for himself, the law office of Mitchell A. Port. He represents individuals, families, and businesses. And the services he offers are in probate, trust administration, estate planning, and tax controversies. Mitch has been in business for 40 years as both an attorney and an IRS collection officer. This part is so very important, and we're going to get to it for people who own their own family businesses. And by the way, he's completely gifted. Welcome, Mitch.
Hi, Judy.
So, Mitch, what is probate? What is a trust? What is a will? And what is estate planning?
Okay.
Tackle those first.
Sure. Well, thank you very much for inviting me to this. I appreciate it. And you were my mediator and did a lovely job. And my divorce was very amicable. So thank you again.
My pleasure. You were great to work with. So thank you for that.
You're welcome. Estate planning basically is a method of making sure that your property transfers to your beneficiaries, whether they're your kids or other family members or charities, in a very efficient way without having to go through the state process known as probate. So when you have a will and a trust, it provides for the distribution of your property when you die. And while you're alive, things happen, and if you become incapacitated, the other parts of the estate plan consist of powers of attorney for managing your assets, and for regarding your health care, there's an advanced health care directive that people sign in order to provide for their own needs, their own health care needs, in the event that they can't provide for themselves. So that's estate planning. If you don't do any estate planning, and you die without a will, for example, or all you draft is a will, when you die, your property has to go through probate, which is simply the court overseeing the transfer of ownership of that property from you as the dead person to your heirs, whoever they happen to be.
But that can get really messy, can't it?
It can get really messy, and it can get really expensive. So a way to circumvent that process of court oversight is to have a living trust and a will prepared while you're alive.
Okay, so this podcast is devoted to divorce and all aspects dealing with divorce. So we're now talking about divorce settlements, right? And my next question then is, how does a trust and a will factor into a divorcing couple's post-divorce transition?
Great question. So if a married couple is in the midst of a divorce and they happen to have done their estate planning while they were married, and they have a will and a trust, typically the trust provides that one of the two spouses can revoke the trust without the participation of the other spouse.
I have no idea.
Yeah, typically that's what the trust provides. If you want to change the terms of the trust with an amendment, that requires both spouses. But if you want to revoke the trust so that it's no longer effective as to your assets, one spouse can do that alone. So, and a court order isn't necessary. You don't need to go through family law court in order to revoke your trust. You simply have to just revoke it and give notice to the other spouse that it's been done.
By giving notice, by revoking it, you have to call the attorney who wrote the trust, right? You can't do it yourself.
You can revoke the trust yourself. Wow. You simply just say in a letter, if you want, to your spouse that you're hereby revoking your trust.
And then don't you have to let the attorney who wrote it know it?
No, because if the trust was, the attorney who wrote it may be completely out of the picture. I've written trusts over the last 3 decades, and many of my clients from a long time ago, if they've gotten divorced, they don't necessarily have to involve me in that process. They can revoke the trust on their own or with their present family law lawyer.
Okay, but they have to give written notice.
Yes.
And is written notice done in a certain way? Is it notarized? Does it have to be FedExed? Well,
it's a good question. There's no formal procedure for the form of the written notice. You merely have to. The trust typically provides for how it's done, and it's pretty straightforward. All you have to do is just say, "I hereby revoke my living trust dated whatever the date it is," and you give a copy of that. You send that notice to your spouse and to the attorneys that are involved in your divorce, and it's done. Now, the property that's in the name of your trust remains in the name of the trust. So it's a little complicated. If the trust is revoked, but the property is still in the trust's name, what's the status of the vesting of the property? So there are some open issues about that, because in the midst of a divorce, you can't transfer title without the consent of the other spouse. So if your house is in your trust and you just revoke the trust, what's the status of the title to your house if you have a revoked trust and you're in the midst of a divorce? I don't know the answer to that question. I think that's a family law issue, so a family law lawyer would know. I would not advise that you revoke the trust without speaking with your family law lawyer or your mediator about that, but it can be done theoretically.
Okay, so then so many people who come here have family trusts, and they have a house and other financial products in it. So you're going through the divorce, everything's being addressed. How do you go from a family trust then to individual trust? I am told, and I'd love you to verify, it happens once the divorce is final?
Well, in the midst of your divorce, you can do any type of estate planning that you want. You can draft any sort of document that you want on your own as a single individual, even if you're still married. You don't necessarily have the right to fund it with marital property until after the property settlement agreement is approved and accepted by all the parties. So you can draft the trust. It will remain empty. It won't have any assets in it because there may not be any assets to contribute to that trust until after the property settlement is done. But once it's done, you can fund that pre-existing trust with whatever property is determined to be yours.
Okay, and you have to break the family trust. Obviously, it's not a family anymore if you're getting divorced.
Correct.
Well, you're still a family connected by your children. This is what we tell people when there are minor children, because it is true. You're just not married anymore.
Correct.
So I want to keep that intact. Okay, next example. When there are minor children of a divorce, and the children could inherit real estate from their parents, how should parents organize so that their children can avoid probate? Is it avoidable?
Great question. So are you, whether you're married or single, you should put your property in your living trust. It's either going to be a joint trust with your spouse or an individual trust that you would have created for yourself. And the property is held by that trust, and the trust contains terms that say when it will be distributed to your minor children. So typically, with my clients who have minor kids, they provide that upon my client's death, property is distributed to their kids, a third at the child's age 25, another third at the child's age 30, and the final third can be distributed to the child at age 35. So the property is held in the trust until the youngest of my client's children turns age 35, for example.
And this avoids probate.
And that avoids probate.
How wonderful. Okay, now, interestingly, we haven't defined this. There are different types of trusts. You mentioned living trust, but then there are irrevocable trusts and revocable. What are the difference in all of these?
Good question. Irrevocable trusts are used typically when an individual no longer needs to own the property. So if I have a life insurance policy, I don't need to own it. It's not maintained for my benefit. It's maintained for the benefit of my beneficiaries who are named in the insurance policy. But it's still an asset of my estate, and it could be taxable if I own it at my death. So I don't want to own it anymore, so I may want to gift it to an irrevocable trust. An irrevocable life insurance trust, for example, will hold my life insurance policy for the benefit of my children. And by making a gift of that policy to the trust, I have gotten rid of that asset out of my estate, so it's not taxable. If I have a taxable estate when I die, that asset will not be counted because I will not own it when I die. My irrevocable trust will own it. And by virtue of the trust being irrevocable, the assets that are in it are not counted as part of my estate.
And they can never be taxed?
Well, they're not subject to estate tax. There may be other taxes involved, but they're not subject to estate tax.
I forgot we have so many taxes. It's really surprising we get to keep any money, isn't it, with all the taxes? Jeez, oh man.
Exactly.
Okay, so this is also very important, and this calls upon another portion of your experience, but this is deadly when this lands in my or anybody's office and we're helping in any way to work with people establishing child support and spousal support. Here's the issue. There'll be, and this is your IRS background we're calling on. So there's a family business. And in the family business, people do what you're never supposed to do, and that is they pay personal expenses out of the business, directly out of the business, so they can zero out and pay no taxes, right? And this is wonderful while they're married and everything is great. Now they're filing for a divorce. And it's time to run what we call the Disomaster for child and spousal support. And they bring their tax returns in, and it diminishes the amount of money the either principals make or the one person who's running the business makes. And of course, this doesn't provide as much spousal and child support as the recipient would like. And we all have to turn to them and say, but this is what you filed. We can't do anything more about this until at which point you change the way you run your business. Mitch, please tell people how vitally important it is to keep business expenses with the business and pay yourself a salary and then pay personal expenses from that. Please flesh this out.
Well, that's a very complicated issue. I am not a CPA, but I do see what you're describing happen frequently. And, sometimes it just may be human nature to run personal expenses through your business if you think it's appropriate or you can get away with it. I think at the time of divorce, however, an accountant would need to be brought in order to somehow figure out how much in personal expenses are paid out of the business, back that out of the equation, and then come up with the Disomaster result that's appropriate after that number has been backed out. It may not seem fair, but it's the lawful thing to do. And I'm not about to say in conversation with you, Judy, that perpetuating an unlawful act by running personal expenses through a business is the answer. That would not be the answer. So there's also ways to equalize the calculation for spousal support even after backing out the business payment of personal expenses. And that would take some clever accounting procedures, and that's where the fight lies, and that's where the mediation comes into play. So discussing with the parties how they would equalize the payments owed by the debtor spouse, the one who has to pay the spousal support, is something right up your alley in terms of mediating that number.
So people prepare for divorce. They do a lot of different things to get themselves organized. In terms of organizing the family business so that the truest and most correct profile of what the business makes gross and what the business truly nets, can you give any advice to people how they can organize so that they can properly represent the income one of the spouses would get from the business and truly do this exercise of spousal and child support correctly?
It seems to me that from a lawyer's perspective, the best option would be for the spouse who's anticipating receipt of alimony and child support to speak with their own independent CPA in order to calculate what the appropriate amount is after correcting all of the reporting that was previously done by the business. So it may not necessarily be information reflected on the tax return, but the books ought to be examined by the spouse who's to receive the alimony and child support to determine how much was being paid personally out of the business, so that that person can continue to receive the appropriate amount in child support and alimony.
That's excellent. That's absolutely excellent. And I'll tell you why I think that's such a good thing that you said. Because it's typical, and it's not bad. It's just the way married people work. One person will handle the finances, the other person will handle something else. And so when it's time to do our taxes, the one person handling the finances will go to the CPA, it'll get all done, and then they bring that for the other spouse to sign. And typically the other spouse doesn't read it. I mean, there's the trust, and that's your job. That's what we assigned for you to do. So the spouse that doesn't look after the finances is generally the one receiving support. And so what you just said, I think, is wonderful, because the person who never really examined the money feels out of the loop, feels insecure, distrust anyway is starting because you're getting divorced. And even though it may be amicable, it's natural just to be fearful and go into protection mode. And so what you just said, hire your own independent person. I would like to talk more about that. I not as an issue of distrust. My whole thrust is amicable. But what I try and tell people is, first of all, you're not being disloyal by talking to attorneys. You're being smart by talking to attorneys. You don't have to have the attorneys negotiate for you necessarily, but you do need to be educated by somebody other than me, who I'm really not licensed to educate. I'm not an attorney. It's not my role. I know the law, but I'm supposed to take two well-informed people and help them negotiate something that works for them. But how would the spouse who needs independent counsel go about finding a CPA? And then what if he or she doesn't have any of the records to provide a new person? What do they do?
Well, the way to find a CPA obviously would be through referrals. So, Judy, if you're connected with competent CPAs who are comfortable working in this sort of environment, then that would be a great place to start. We all know other people who have been divorced, and perhaps they've worked with their CPAs.
Do you have really good people you could also provide?
I have people that I would be willing to refer your clients to. And in terms of getting the records, if they're mediating, one of the things that would be subject to mediation would be the turning over of those records. Another would be that if there are lawyers representing each spouse, then the discovery process that goes on in the context of that divorce would reveal those records as well. And those are the only ways that I can think of in order to help determine what the proper numbers ought to be.
I think that's great. People are fearful, and yes, you're absolutely right. As part of the discovery, they're brought. If for some reason the other spouse who has them doesn't bring them, is this true or untrue? That whoever signs off on a tax return has every right to access that tax return independently from the person who executed it. Is that a true or false statement?
I think that's true. So, but having access to the tax return is not the same as having access to the records that made up the information that went into the tax return. And so both spouses do sign the tax return, making them joint and severally liable for the tax that's reported. But that doesn't necessarily give the spouse without the records the right to those records just because he or she signed the tax return.
No, but at least to start with the return itself, because the spouse that doesn't handle it typically says to me, well, I don't know what to do. He or she has a copy. I can't get it out of the files. It's in the office. I can't get there. How do I get it? And I always thought that if you are a signer, you can have access to that by calling the accountant who wrote it.
As the signer of the tax return, you have access to the tax return. You can probably get it directly from the IRS or from the Franchise Tax Board, because those agencies will determine that indeed you're a signer, and that if the income and expenses being reported on the return are yours, then you're entitled to get a copy of the tax return itself. So if you have trouble getting it from your spouse, from the accountant that prepared the return, from your spouse's attorney, then you can go directly to the agencies, the IRS and the Franchise Tax Board, to get that copy.
Excellent, excellent, excellent. I'm circling back to the first part of our conversation, and my question is, what are some issues that could arise if people don't protect their assets properly as they transition out of the divorce?
My most favorite case in the last couple of years was so much fun. I represented the personal representative, the executor. So she was not involved directly in the fight, but the fight was resulted from a probate that I started on my client's behalf of her father's house. And there were two women who came forward claiming to be the dead guy's surviving spouse. There were two women who came forward saying that they were his wife. Now, how did that happen? The first woman was married to the decedent in the 60s, and she wanted a divorce, and his attitude was, you take care of it, I don't want to be involved, don't ever contact me, just do it on your own. So she did everything on her own, but she never got a final judgment, a final decree of divorce. But she did manage to get a child support order for the two children that they had together. So they were never formally divorced. 45 years go by. Each of them believes that they're officially and legally divorced. They had no communication whatsoever. The decedent, the dead guy, never had any connection with the two children that he had with the woman he was married to in the 60s. So about a couple years before he dies, he remarries. And he had no reason to believe he was still married to his first wife. And the woman he married had no legal obligation to determine whether or not he was single or officially divorced. So they got married, and then he died. So was the second woman involved in a bigamous marriage? Is the first woman allowed to sit on her rights and come forward claiming to be his surviving spouse after 45 years of being totally separate? So it was a fascinating case. It was mediated by a retired judge. And everybody got a little piece of it. And the first spouse's claim of being the surviving spouse didn't carry much weight, but her child support order carried a lot of weight on her behalf. And though her kids were now in their 50s, the child support had accumulated over 45 years with interest and added up to a significant amount of money. So she was able to leverage that and compel a settlement to her advantage for that unpaid child support that went on and on and on for all those years.
Wait a minute.
And that was all in probate.
Okay, that is extremely fascinating, but so many red flags went up as you told that story. First, you can't get divorced without serving the other person, and their signature has to be somewhere. And that's fascinating to me that people to this day say, do whatever you want. Well, you can't. Mm-hmm. You have to have a little bit of interaction and signature from the other spouse. Okay, so I guess people just don't realize that. I guess people think one person can execute the whole divorce. Is that what you saw?
Apparently, that's what he thought in the early 60s.
And this was California?
This was all in California.
This was all in California. Okay, that's fascinating unto itself. Number two, the other thing you said was that the way the case was settled was that there was this accumulation of child support that became the amount of money upon which some decisions were made. But I don't understand that, because child support cuts off when each child graduates from high school. Did he ever pay child support during that time?
He never paid child support. It stopped when the child turned age 18, but interest on unpaid child support continues to run, and it had run for 40 years or so. So the interest on the amount that was due when each child turned age 18 added up and became a significant amount of money all those years later.
Why didn't the first wife follow up on child support? She put the child support order in, but then she let it go?
Evidently, I don't know why she let it go, but she did. And then asserted her claim after her ex-husband's death, when I was involved in his probate. So to avoid all of that, he could have had a living trust. The first spouse may have asserted a claim, but there would have been no probate in which to assert that claim. She may not ever have known that her ex-husband had died, because there would be no reason to give her notice. But by having to go through probate, notice was given to all who were concerned with his death, including his first wife.
Okay, since so many years had gone by, how can you go back in time and find people and see who the right people are that would be part of this case? I don't understand that.
Good question. Well, there's no obligation to go back in time, but you do have to publish a notice of death in a newspaper.
Oh, right.
And people read that newspaper. And so do companies, on behalf of people, read that newspaper. And they sell that information to people who the company believes may benefit from making a claim. So they'll approach the first wife and say, we think you may have a claim. We'd like to provide you with all the information relevant to your claim, and we would like to, charge a fee for that information. And that's how I think she found out about it.
Now, the remaining wife, the second wife who got married, well, I mean, he's dead, so nothing happened to her, right? Or how did she fare in the settlement?
Good question. Because he died without a will, the law determines what happens with the surviving spouse's share of the estate. So she was making her claim based on intestate succession. And there are very strict rules that apply in that circumstance. But the question was whether or not she was legally married to him in order to make a claim as his surviving spouse. So there was an argument against her claim because their marriage was bigamous. He was married to two people at once. So that diminished the value of her claim. And so she negotiated a settlement.
A weird thing just came to mind. So what if there was real estate, a family residence in the first marriage, and the wife who executed the divorce on her own but never really finalized it? Oh my gosh, wait a minute. She never finalized it. Didn't she get any flack from the court for not finalizing it?
Well, that diminished the value of her claim.
Okay, because she was in charge. But Mitch, so what if he remained in the family house from the first marriage? She left, does other things. And the second wife Oh my gosh, the second wife thinks it's her house, but if they never retitled it, it's really not her house. Oh, this is really complicated.
That's not what happens, but you're right. Let's say that the decedent owned the property in joint tenancy with his first wife, and they got divorced, and she never got a final judgment in that divorce. And then the man married 40 years later, but still held title to the property as a joint tenant with his first spouse. Upon his death, rules of joint tenancy take over.
Go right back to her.
Right, go back to the first spouse.
Oh gosh. Oh my.
That didn't happen, but that could have happened. I haven't had a case like that yet, but I expect something like that may come along.
So many fascinating things related to your business. And you know, it's funny, and this just may be me, but there are things that are, for lack of a better word, kind of sexy and interesting in the divorce arena, and then some things that seem a little bit drier. And wills, estate planning, for those who are wealthy may not be very dry, but for those of us who make regular money, it's kind of a foreign entity. But does this apply to everybody? Everybody, regardless of what they make for a living? Should they really investigate a good will, estate planning, trusts?
If you own real estate in California, or if you have assets worth more than $150,000, then a living trust ought to be seriously considered, because those two defining elements under California law say that if you have either real estate or assets worth more than $150,000, when you die, it has to go through probate. So a living trust avoids probate. Regardless of what your income is or what your status is, if you own assets like that, that would go through probate, then a living trust should seriously be considered in order to avoid the probate process.
Okay, do pensions fall into this $150,000 net worth?
Pensions and life insurance and items governed by contract law, such as those two things, do not fall into the $150,000 net worth.
Okay, but other financial investments, independent of retirement plans, and real estate?
Yes, those assets contribute to the calculation of whether or not you have more than $150,000. And the value of the real estate is almost always in California worth more than $150,000. So if you own any real estate and you're retired and you're not earning an income, or you're unemployed, it doesn't make any difference. When you die, the probate rules apply, all of which can be avoided if you have a living trust in place and your real estate is owned by your living trust.
Okay, so this is, in conclusion, why people seriously have to come and see you. And in order to do that, Mitch, would you like to please give some contact information?
Sure. I have a website at www.askmyattorney.net. I have a blog that you can read about probate and estate planning. And my phone number is 310-559-5259.
Give it again.
310-559-5259.
What's the name of your blog?
It's Ask My Attorney. It's California California Probate Blog .net, and the other blog is CaliforniaTaxBlog.net.
Excellent. Mitch, this has been a lot of fun. Thank you so much for being a guest on the show.
My pleasure. Thank you, Judy.
So you have been listening to Constructive Uncoupling, the podcast devoted to amicable divorces. I hope you gained a lot of information out of this episode. You can contact me, Judy Weigel, through my email address, Judy, Judy, at constructiveuncoupling.com. Judy, Judy, at constructiveuncoupling.com, or you can go through my website, divorceresourceinc.com. divorceresourceinc.com. I'm in Los Angeles, California, and I look forward to our next episode.